If you or your spouse ever enters a nursing home and you have not taken specific legal steps to protect your home before that happens, the state may have the legal authority to place a claim against your house after you pass and collect on that claim before your children inherit a single dollar. This process is already underway in every state in the country. It operates silently. It has a 5-year look-back window, and most families discover it only after the window has already closed. Understand what is being said here. Not as a hypothetical future risk, as a legal mechanism operating right now in 2026 under federal Medicaid law and state-to-state recovery statutes that allows state governments to recover the cost of nursing home care from the estates of Medicaid recipients after their death. Your home is the primary asset most states target in these recovery actions, and the 5-year look-back period that precedes any Medicaid application means the clock on protecting your home started 5 years before you will ever need to use Medicaid, which means for many families, the best window for protection has already partially closed. The average annual cost of nursing home care in the United States in 2026 is approximately $108,000 per year for a semi-private room. The average length of a nursing home stay is 2.5 years. The average Medicaid estate recovery claim against a homeowner's estate in states with active recovery programs is between $93,000 and $215,000 depending on care duration, the state's recovery methodology, and the value of the home. These are not outlier figures. They are the documented outcomes for families who did not take the legal steps described in this video. Steps that, taken more than 5 years before a Medicaid application, can protect the home entirely. We are going to walk through 6 legal strategies and protective actions every homeowner over 60 needs to understand. How Medicaid estate recovery works, who it affects, what the 5-year look-back clock means for your specific timeline, and the specific legal tools that can protect your home before the window closes. And item number 5, the strategy most elder law attorneys identify as the most powerful protection available, is the one most families have never heard of and never implement until it is too late to use it. We will reach it before this video ends. Stay with us. Here is what most families do not understand about how Medicaid and nursing home costs actually work. Medicaid is a joint federal and state program that covers long-term care costs, nursing home stays, skilled nursing facility care, and in some states, home-based care (GEO) for individuals who meet financial eligibility requirements. The federal government sets the framework, states administer the program and establish the specific rules for asset counting, income limits, and, most critically, estate recovery. Under federal law, every state is required to attempt to recover the cost of Medicaid-funded long-term care from the estates of recipients who were 55 or older when they received benefits. This is the Medicaid Estate Recovery Program, MERP. The primary target of MERP in most states is the Medicaid recipient's home, because for most seniors, the home is the largest asset in the estate, and it is the asset most likely to have value remaining after a nursing home stay depletes other savings. The mechanism works as follows. A senior qualifies for Medicaid by spending down their countable assets below the state's eligibility threshold, typically $2,000 for an individual. The primary residence is generally not counted as a disqualifying asset while the recipient intends to return home or while a spouse or qualifying dependent remains in the home. Medicaid begins paying for care after the recipient's death, and in most states, after the surviving spouse's death, the state files a claim against the estate for the total cost of care Medicaid paid. If the home is in the estate, the state's claim must be satisfied before the home can transfer to the heirs. In many cases, the family must sell the home to pay the claim. 3 federal agencies, the Centers for Medicare and Medicaid Services, the Department of Health and Human Services, and the Social Security Administration are all involved in the framework that governs this process. The system was designed in 1993 as part of the Omnibus Budget Reconciliation Act and has been actively enforced and expanded since. It is not going away. The system was not built to protect your family's inheritance. It was built to recover public expenditures. And it does so automatically, systematically, and against the estates of families who did not plan ahead. Here are 6 things every homeowner needs to know, starting with the mechanism that catches the most families off guard. Strategy number 1, understanding the 5-year look-back and calculating where your clock actually stands today. The 5-year look-back is the central mechanism through which Medicaid evaluates whether an applicant has transferred assets in a way designed to qualify for Medicaid while protecting wealth from estate recovery. Understanding it precisely, not approximately, is the foundation of every protective strategy that follows. Here's how it works. When you apply for Medicaid long-term care coverage, the state reviews every financial transaction you have made in the 5 years immediately preceding your application date. Every asset transfer, every gift, every sale below fair market value, every trust funding. If any of these transactions are identified as transfers for less than fair market value made within that 5-year window, Medicaid calculates a penalty period, a defined number of months during which Medicaid will not pay for your care, regardless of your current financial situation. Here is the penalty calculation that makes this concrete. The penalty period is calculated by dividing the total value of the disqualifying transfers by the average monthly cost of nursing home care in your state. In 2026, that average monthly cost ranges from $7,500 to $11,000 across states. If you transferred your home valued at $280,000 to your adult child 18 months before applying for Medicaid, the disqualifying transfer amount is $280,000. Divided by a $9,000 monthly nursing home cost, the penalty period is 31 months. During those 31 months, Medicaid pays nothing. Your family must find $9,000 per month from somewhere, a monthly cost that most families cannot sustain, during a period when the assets that could have funded it have already been transferred away. Here is the first detail most families miss. The penalty period does not begin on the date of the transfer. In most states, it begins on the date the applicant is otherwise eligible for Medicaid, meaning the applicant must be in a nursing facility, have spent down to the asset threshold, and have applied before the penalty clock even starts. This means a family that transfers assets and then immediately needs care faces a penalty period during which the senior is in a facility, Medicaid is not paying, the transferred assets may not be available to cover care, and the family has no legal mechanism to recover from the situation. Here's the second detail most families miss. Assets transferred more than 5 years before the Medicaid application date are entirely outside the look-back window and generate no penalty, regardless of their value. A home transferred to a trust, a child, or another qualifying recipient 61 months before a Medicaid application is fully protected, generating no penalty period. A home transferred 59 months before the same application is fully within the look-back window, generating a full penalty on its value. A retired couple in Wisconsin, he 71, she 68, both in good health at the time, consulted an elder law attorney and transferred their home into a Medicaid asset protection trust. The home was valued at $295,000. Both spouses were healthy and had no anticipated nursing home needs. 6 years later, the husband was diagnosed with a condition requiring memory care facility placement. Because the trust had been funded 69 months before the Medicaid application, well outside the 5-year look-back, the home generated zero penalty. Medicaid covered the husband's care costs. Upon his death and subsequently his wife's death, the home passed to their adult children according to the trust terms, free of any Medicaid estate recovery claim. The elder law attorney's fee for the trust, $4,800. The care costs Medicaid paid on the husband's behalf over his 4-year stay, approximately $432,000. In Wisconsin, Michigan, and Minnesota, states with both significant senior populations and active Medicaid estate recovery programs, elder law attorneys consistently report that the most common factor in unsuccessful Medicaid planning is families who waited too long to start the clock. The 5-year look-back is not a threat in the future. It is a calculation running against your current age and health right now. What to do? Calculate where your 5-year clock stands today. If you are 65 or older and in reasonable health, you may have a meaningful window to implement protective strategies before a nursing home need materializes. If you are 70 or older with significant health risk factors, family history, chronic conditions, mobility concerns, your window may be shorter than you assume. Contact an elder law attorney within the next 60 days and ask them to calculate your specific look-back exposure based on your age, health history, asset picture, and state of residence. This calculation is the foundation of every strategy that follows. Strategy number 2, the Community Spouse Resource Allowance. The protection most married couples do not know exists while one spouse is still at home. Medicaid's asset rules are often described as requiring a senior to spend down to $2,000 before qualifying for coverage. For a single individual, that is largely accurate. For a married couple, the rules are significantly different and significantly more protective than most families understand. When one spouse requires nursing home care and applies for Medicaid, the other spouse called the community spouse, is not required to impoverish themselves for the institutionalized spouse to qualify. Federal Medicaid law specifically protects a defined amount of the couple's combined assets for the community spouse, an amount called the community spouse resource allowance. Here is the dollar structure of this protection in 2026. The Community Spouse Resource Allowance is calculated as the greater of a minimum floor and 50% of the couple's combined countable assets at the time of institutionalization, up to a maximum cap. The minimum floor in 2026 is approximately $30,828. The maximum cap is approximately $154,140. This means a community spouse can retain between $30,828 and $154,140 in countable assets after the institutionalized spouse qualifies for Medicaid, regardless of how low the couple's combined assets have fallen. Additionally, the community spouse is protected by the Minimum Monthly Maintenance Needs Allowance, MMMNA, which ensures that the community spouse retains enough monthly income to meet their basic living expenses. In 2026, the minimum MMMNA is approximately $2,555 per month. If the community spouse's own income is below this threshold, a portion of the institutionalized spouse's income, which would otherwise go toward the cost of their care, is diverted to the community spouse to bring their income up to this floor. Here is the critical detail most couples do not know. The Community Spouse Resource Allowance protects countable assets, cash, investments, most financial accounts. The primary home is generally not counted as a Medicaid asset for the community spouse's purposes while the community spouse lives in it, but the home becomes subject to estate recovery after the community spouse's death. This is where the distinction between asset protection during life and estate recovery after death becomes crucial, and where the strategies in items 4 and 5 of this video become essential. A couple in Ohio, he's 78 requiring nursing home placement, she 74 remaining in the community, had combined assets of $310,000 excluding their home. Ohio's Community Spouse Resource Allowance allowed the wife to retain $154,140 of these assets, while the husband qualified for Medicaid. The husband's remaining assets of approximately $155,860 were spent down toward his care costs before Medicaid coverage began, a period of approximately 17 months at $9,000 per month. Medicaid then covered his care for the following 3 years. After both spouses passed, the home, valued at $298,000, was subject to Ohio's estate recovery claim for the Medicaid benefits paid. Without prior planning, the estate recovery claim consumed approximately $194,000 of the home's value before it could transfer to the children. In Ohio, Indiana, and Iowa, states with comprehensive Medicaid estate recovery programs that extend to the full cost of care, the Community Spouse Resource Allowance protects the living spouse's financial stability but does not protect the home from post-death recovery. Understanding this distinction is essential to using the strategies in the second half of this video. What to do? If you are married, ask your elder law attorney to calculate your specific Community Spouse Resource Allowance and MMMNA based on your state's rules and your current combined asset picture. This calculation tells you how much of your financial assets would be protected for the community spouse in a nursing home scenario, and how much exposure remains for the home through estate recovery. That remaining exposure is what items 4 and 5 address. There are 4 more strategies ahead. And item number 5, the trust structure that elder law attorneys call the most powerful home protection tool available, is still coming. Keep watching. Strategy number 3, estate recovery exceptions, the circumstances under which the state cannot pursue your home. Medicaid estate recovery is not absolute. Federal law requires states to establish hardship waiver procedures and specific exceptions under which the recovery claim against a home can be reduced, deferred, or waived entirely. Most families whose estates face a recovery claim never learn that these exceptions exist and never apply for them. Here is the list of federally required and commonly available exceptions to Medicaid estate recovery that apply to the primary residence. The undue hardship exception. If the estate recovery claim would deprive an heir of their primary source of livelihood, for example, a family farm or a small business operated from the property, or would deprive a low-income heir of housing with no alternative available, the state may waive or reduce the recovery claim. The application for a hardship waiver must typically be filed within a defined window after the recipient's death. often 60 to 90 days, and requires documentation of the heir's financial circumstances and the hardship the recovery would cause. The sibling exception. If a sibling of the Medicaid recipient had an equity interest in the home and lived in the home for at least 1 year before the recipient entered the nursing facility, the state may not recover against the sibling's share of the home. The caregiver child exception. If an adult child of the Medicaid recipient lived in the home for at least 2 years immediately before the recipient entered a nursing facility and can demonstrate that their care delayed or prevented the recipient's institutionalization, thereby reducing the amount of Medicaid expenditure that would otherwise have been incurred, the state may be required to exempt the home from estate recovery or transfer it to the caregiver child without a recovery claim. Here is the dollar magnitude of the caregiver child exception specifically. A home worth $320,000 that qualifies for the caregiver child exception passes to the qualifying child free of the estate recovery claim, eliminating what might otherwise be a $150,000 to $200,000 claim against the estate. The requirements are specific and the documentation standards are high, but for families where an adult child has been providing care in the home, this exception can be the most financially significant single factor in the estate. Here is the detail most families miss. The caregiver child exception is not self-executing. It does not apply automatically because a child lived in the home and provided care. It must be applied for, documented, and approved by the state Medicaid agency. The documentation requirements include proof of continuous residence in the home for at least 2 years, physician statements documenting the level of care provided, and evidence that the care provided allowed the parent to remain at home and out of a facility for longer than would otherwise have been possible. Families who did not anticipate this exception and did not document the caregiving relationship while it was occurring are often unable to prove the claim after the fact. A family in Pennsylvania, an adult daughter who had lived with her mother for 3 years, managing her care through advancing dementia before the mother required nursing home placement, applied for the caregiver child exception after the mother's death. The mother's home was valued at $285,000. Pennsylvania's Medicaid estate recovery claim was $187,000. The daughter documented her continuous residence, provided physician letters from her mother's neurologist confirming that the daughter's care had delayed nursing home placement by an estimated 2 years, and submitted tax records showing her residence at the home address. Pennsylvania approved the exception. The estate recovery claim was waived. The home transferred to the daughter without the $187,000 claim. In Pennsylvania, New York, and Massachusetts, states where the caregiver child exception is actively adjudicated, elder law attorneys report that families with qualifying caregiver child situations who apply for the exception have high rates of success when the documentation is in order. Families who did not know the exception existed file no application. The default is recovery. What to do? If an adult child currently lives in your home and provides caregiving support, begin documenting that relationship now in writing, with dated records of the care provided and physician statements acknowledging the care's role in maintaining your ability to remain at home. Consult an elder law attorney about the specific documentation standards in your state. And if you have already experienced a nursing home placement and received a Medicaid estate recovery notice, ask the elder law attorney immediately about available exceptions and the application deadline. Strategy number 4, the life estate deed, a faster, lower-cost protection tool and its significant limitations. Before the Medicaid Asset Protection Trust, which we will cover in Item 5, became the standard recommendation among elder law attorneys for home protection, the life estate deed was the most commonly used tool for removing a home from the Medicaid estate recovery target while allowing the owner to remain in the home for life. A life estate deed transfers the future ownership of a home, called the remainder interest (chow), to named beneficiaries, typically adult children, while reserving the right for the current owner, called the life tenant, to live in and use the home for the rest of their life. The life tenant cannot be removed from the home. The remaindermen, the beneficiaries named in the deed, have no right to occupy or sell the home during the life tenant's lifetime. At the life tenant's death, full ownership passes automatically to the remaindermen outside of probate, because the transfer has already been documented in the recorded deed. Here is the Medicaid protection this tool provides. When a life estate deed is executed and recorded more than 5 years before a Medicaid application, clearing the 5-year lookback, the value of the remainder interest is no longer considered a countable asset for Medicaid purposes. The transfer is complete, the look-back period has expired, the remainder interest passes to the children outside the estate and outside the reach of Medicaid estate recovery, and because at the time of the life tenant's death, the home does not pass through the estate. It passes through the deed directly to the remaindermen by operation of the recorded document. Here's the dollar cost comparison that makes this tool attractive to many families. A life estate deed is typically prepared by an estate planning or elder law attorney for between $500 and $1,500, significantly less than the $3,000 to $6,000 cost of a Medicaid asset protection trust. The recording fee at the county recorder's office is typically between $30 and $100. For families with straightforward circumstances and a clear 5-year planning window, the life estate deed can accomplish the primary home protection goal at substantially lower cost. Here's where the tool's limitations become critical. A life estate deed is irrevocable once recorded. The life tenant cannot change their mind about who receives the remainder interest without the cooperation of all remaindermen. If the life tenant needs to sell the home during their lifetime, to fund a move to a different location, to access equity for living expenses, or to downsize, all remaindermen must sign the sale documents, and the proceeds must be divided between the life tenant's life estate value and the remaindermen's remainder value according to actuarial tables. The life tenant does not receive the full sale price. If any remainderman is unable or unwilling to cooperate, the sale may be legally complicated or impossible. Additionally, the remaindermen's receipt of the home at the life tenant's death under a life estate deed does not receive a full step-up in cost basis the way it would under a properly structured trust in some circumstances, while a distinction that can have capital gains tax implications for the children when they eventually sell. A retired widow in Ohio executed a life estate deed naming her 2 adult children as remaindermen when she was 68, 9 years before she required nursing home placement. The deed cleared the 5-year look-back with 4 years to spare. When she entered a nursing home at 77 and subsequently qualified for Medicaid, the home was not subject to estate recovery because the remainder interest had already been transferred and the transfer was outside the look-back window. Her 2 children received the home at her death through the deed outside of probate with no Medicaid recovery claim. The cost of the life estate deed preparation and recording $820. In Ohio, Indiana, and Virginia, states where life estate deeds are commonly used as a Medicaid planning tool, elder law attorneys report that the tool works well for straightforward family situations with a clear planning horizon but generates complications when family circumstances change. A child's death, a divorce, a need to sell after the deed has been recorded. What to do? If you are considering a life estate deed as a home protection strategy, discuss the specific implications with an elder law attorney before executing the document. Ask specifically about what happens if you need to sell the home, if a remainderman predeceases you, or if a remainderman's circumstances change in ways that affect the property. The life estate deed is a faster and less expensive tool than the trust in item 5, but it is less flexible and carries risks that the trust structure addresses. For many families, the right choice depends on age, health, family circumstances, and the value of the home. Here is what you do this week. Step 1. Calculate your 5-year look-back exposure today. Determine whether any significant asset transfers, gifts to children, property transfers, trust fundings, have been made in the past 5 years. If so, consult an elder law attorney about the Medicaid implications of those transfers and whether any corrective action is available. If no transfers have been made, your 5-year clock starts from scratch when you implement a protective strategy, and the best time to start that clock is now. Step 2. Schedule a consultation with a licensed elder law attorney within 60 days, not a general estate planning attorney. An attorney who specializes specifically in Medicaid planning and elder law. Before the appointment, prepare a summary of your home's approximate value, your other liquid and countable assets, your monthly income sources, your current health situation, and your family health history. Ask the attorney specifically about the 5-year look-back period relative to your current age and health, the Medicaid estate recovery rules in your state, the Medicaid Asset Protection Trust as a home protection tool, and what the specific cost and timeline would be to implement it. Initial elder law consultations range from $200 to $400. Step 3. If you have a spouse, ask the elder law attorney to calculate your community spouse resource allowance and your minimum monthly maintenance needs allowance based on your state's current rules and your combined asset picture. This calculation tells you how much financial protection the law already provides for the community spouse and how much additional protection your home needs through a trust or deed strategy to be fully protected from estate recovery. Step 4. Review whether your state offers a long-term care partnership program. These programs, available in most states, allow seniors who purchase qualifying long-term care insurance policies to protect a dollar of assets for every dollar the insurance policy pays in benefits. A policy that pays $200,000 in long-term care benefits allows the policyholder to protect $200,000 in additional assets from Medicaid spend-down requirements, a significant complement to the trust strategy for families who also want insurance protection against care costs. Ask your elder law attorney whether this program is available in your state and whether it is appropriate for your situation. Step 5. If you are married and one spouse has recently entered a nursing home without prior planning, contact an elder law attorney this week about the spousal home transfer. Ask specifically about executing a deed transfer from joint ownership to the community spouse's sole ownership before the Medicaid application is filed, and about what subsequent community spouse planning options are available to further protect the home from estate recovery at the community spouse's death. Time is the most critical variable in crisis Medicaid planning. Every week of delay narrows the available options. You did not build that home to surrender it to a government recovery claim. You made the payments through the hard years. You stayed when you could have sold. You maintained it, improved it, paid taxes on it, and protected it through every challenge your life presented, because it was not just a house. It was the foundation of everything your family stands on. The Medicaid estate recovery system does not know that. It sees an asset. It sees a claim it is legally authorized to make, and it makes that claim automatically against every estate where prior planning has not removed the home from its reach. Not because your family did anything wrong, because no one told you the clock was running, and by the time most families discover the clock exists, it has already expired. Your spouse should not lose the house they raised children in because a nursing home placement happened before a trust was funded. Your children should not sell a home you paid off over 30 years to satisfy a government recovery claim on care costs the system was designed to cover. The trust exists. The law allows it. The 5-year clock can still run if you start it now. Take action this week. Protect what you built. If you know a homeowner over 60 who has never heard of Medicaid estate recovery, the 5-year Lookback, or the Medicaid Asset Protection Trust, a parent, a neighbor, a sibling, share this video with them today. The clock they do not know is already running. The sooner they know, the more time they have. Next week, we are covering the one property tax protection that survives a nursing home placement and the specific filing that keeps your property tax exemptions active while you are in a facility, protecting the home for the spouse or family member who remains. You will not want to miss it.